Honors, good afternoon. This is a continuation of the public panel interview of candidates for the positions of Associate Justice of the Supreme Court, Vice Justice Francis Jardeleza, and Justice Antonio T. Carpio. The candidates for panel interview this afternoon are the following: Justice Edgardo LLOREN, Justice Edwin Sorongon, and Ambassador Manuel Antonio TEEHANKEE. Gentlemen, can I request you to raise your right hand so that I can administer the oath? Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview by the Judicial and Bar Council? So help you God. You may now be seated. Your
The
Honors.
first interviewer will be Judge De Monteverde. Judge.
Thank you, Chairman. Okay, I will direct this question to Justice Edwin Sorongon.
Yes, Your Honor.
If appointed to the Supreme Court, what do you think will be the biggest adjustment you will be facing, coming, of course, from the Court of Appeals for 9 years? And what challenges do you foresee if appointed?
Well, first, I will have to study more and acquaint myself with jurisprudence and existing laws. Because while it is true that in the CA we have been doing a lot of education, research, and writing decisions, but in the Supreme Court, the cases being brought before it are of great importance, and it affects not only small portion of people but the entire population, and it also affects the entire spectrum of our society and government and the people, entire people as well. So in that sense, I have to do a lot of thoughts, of dedication, hard work here in the Supreme Court. Thank you.
Shall I continue? Okay. By the way, how is your health status for the past 5 years?
Well, I would describe that I'm healthy, I'm good, I'm fine. Of course, I just have a physical examination a month ago,
And what's the result?
except for my blood sugar. It's quite, not really high, but according to my doctor, it's manageable.
Do you take any medication?
Yes, Your Honor. I have my maintenance for my blood sugar.
You're a diabetic?
I don't consider myself a diabetic. I only have a high blood sugar.
And what's your blood sugar at?
Well, it's now 6.8,
And
6.7.
equivalent to 100?
112, 100.
That's
yeah,
normal.
Yeah, 112 or 150.
Now, what was the biggest controversy you had faced as part of the judiciary?
In terms of cases, Your Honor, or where I maybe last year I consider it the biggest controversy that I experienced while I'm a member of the Court of Appeals was when we issued an order. By the way, I was just an special member of that division, and the original members heard and decided to issue an order directing the Sergeant at Arms of Congress to explain why he should not be cited in contempt. That was the last order they have before I came in as a special member of that division. So when I entered that special division, there was already an order directing the Sergeant at Arms to explain why he should not be cited in contempt for not appearing and answering our query. What we got is what you call this? The speaker then was interviewed over the radio, and he lambasted us and called us all kinds of innuendos. So that was the biggest challenge. Then they challenged us that if we will not show up, they will arrest us and put us in Congress for a certain period of time.
And how did you deal with it?
Well, we wrote the Supreme Court and explained to them our position. And likewise, we continued in hearing the case. In fact, after that hearing, we issued another order issuing an order releasing to issue an order to release the 5 provincial officers of Ilocos to be released. That angered more the speaker. So incidentally, after several weeks, there was a budget hearing. We were called, and the speaker, we will not approve the budget of the Court of Appeals or the Judiciary as a whole if we will not appear, if we will not show up. So we went to Congress, I and the chairman of the division, and we explained our side to the speaker. And they also listened to us. That was the end of the story.
Okay. Recently, we have this case of the GCTA.
Yes, Your Honor.
The Bureau of Corrections had revealed that it had already released 1,914 heinous crimes convicts because it applied at that time an interpretation that the GCTA law covered all types of prisoners. However, the palace said that it wanted to send back to jail the 1,914 convicts who were released on the basis of GCTA. Is it right to send these people back to jail after releasing them? And do we have a jurisprudence that tells us that we can send them back to jail?
Yes, Your Honor. We can send them back to jail. Yes, it's true that they have their own interpretation. How erroneous is that interpretation? We are bound by it. But my take here is that should have been done in good faith. In this particular case, the Bucor was not acting in good faith.
How come?
They have well, I just read it in newspapers and during the Senate hearing, I was listening over the radio and watching the TV, and there were some instances that the Bucor were not doing their work in accordance with the law, and they made some allegations which were not really true. So, to my mind, they were not acting in good faith when they released some of these 1,900 prisoners. Now, if there is a jurisprudence, I will answer in the affirmative because there is the case of Fidel Tan, which was also mentioned in the newspapers and during the Senate hearing.
I believe you are familiar with the exclusive economic zone.
I have heard, but I'm not really.
Anyway, I'll give you
Yes.
a question, a differentiation merely between sovereignty and sovereign rights. Do we have sovereignty or sovereign rights over the exclusive economic zone for the Philippines?
I think we have this sovereignty of the economic zone.
Expound your answer.
Yeah. It's within our territory, and as such, it's falling under our sovereignty. Economic zone is part of the Philippine territory, and we just use it for economic purposes for other countries to use it for their own benefit as well. But we maintain sovereignty over it, Your Honor.
Okay, let's go back to GCTA. The PNP said that if released of heinous crime convicts due to GCTA, the law is revoked. They can be arrested again without any warrant. What is your take on this?
Well, they can be rearrested because they have not yet finished their service of sentence. They still have to continue serving their sentence, Your Honor. So they can still be rearrested, not on the argument that the GCTA has been revoked.
Recently, the DOJ had filed anti-money laundering charges against 5 executives of the RCBC.
Yes, Your Honor.
You still remember that?
Yes, Your Honor.
Okay. The DOJ noted that the officers still allowed the transaction to push through, even if there were evident red flags. So when they filed a motion for reconsideration, the prosecution, the DOJ denied the motion of the respondents. The doctrine in denying the motion for reconsideration, it was noted that the doctrine used by the prosecutors was willful blindness. Can you expound on this willful blindness doctrine?
I'll try my best. Willful blindness, one who is actually aware, of a commission of a crime, but obviously he is trying to avoid and make an investigation on it. That's, I think, is trying to avoid investigating it, although he knows for a fact that there was indeed a crime that has been committed. Yes, that's my understanding.
Okay, my last question. Differentiate the use of doctrine of incorporation from doctrine of transformation.
Doctrine of
Just
transformation.
if you cannot remember the exact, the verbatim explanation of this, just in your own words, doctrine of incorporation and doctrine of transformation.
Well, incorporation, maybe it refers to a corporation or a group of people No, incorporation where a group of persons trying to form an incorporation, or trying to form a corporation, and they call themselves as incorporators, while transformation is when they're trying to change the nature of the corporations that they have. I'm sorry, Your Honor.
Anyway, that was my last question. Thank you and good luck, Justice.
Thank you.
Justice Tia.
Thank you, Mr. Chairman. Good afternoon, Your Honors.
Good afternoon.
You might have been surprised why we conducted a group interview. The purpose actually is to gauge you, how you respond in a collegial setting, because if appointed to the Supreme Court, you will be working with 14 other justices of the court. So let me just reiterate the same questions asked by Judge de Monteverde. The doctrine of incorporation and the doctrine of transformation in international law. Justice LLOREN, do you have any idea what it means?
Good afternoon, Your Honors. I'll try my... In the Constitution, it's stated that Philippines adopt the international law as part of the law of the land and adhere to the policy of peace, equality, and amity among all nations, and renounce war as instrument of national policy. So therefore, since article of incorporation, so that international is part of the law of the land, so that is included in our laws, Your Honor.
What about doctrine of transformation? What is your understanding of that doctrine in international law?
I think when an ambassador or consul declares a policy adopting the policy of other countries, it should be passed through the legislative body in order to be part of the law of the land, Your Honor.
Ambassador TEEHANKEE, what is your understanding of the doctrine of incorporation as distinguished from the doctrine of transformation in international law?
Good afternoon, Honorable Justices, members of the Judicial and Bar Council. I would just like to express my appreciation for being afforded this opportunity and to go direct to the question of Justice Tiham. My understanding, of course, this is one of the tricky concepts in international law as to the theory of international law. The question is whether international law forms its own integral system, or whether there are two systems of law vis-a-vis international law and the domestic or national legal system. Under my understanding, of course, there are fine references to this, but the doctrine of incorporation requires that there are actually two systems of law, and by virtue of domestic legislation, there is a need to incorporate. There must be a domestic provision of law in order to incorporate international law into the local system. And as cited by Justice LLOREN, we do have a constitutional provision that says international law shall form part of the law of the land. There are two theories by which it can become part of the law of the land. One is by incorporation by a domestic reference, or transformation, which yields more to the unitary theory of international law, which means that the international law is transformed automatically as part of one system of law. And so, while I do need to refresh my understanding of this nuance. For example, by example, the United States follows very strictly that international law does not automatically get incorporated into its domestic law. And there is a need for legislation to incorporate international law. So they follow very much the dual theory of international law, that there are two separate systems and they require linkages. While in the unitary system, international law, or the monist theory, international law adopts a kind of superior mechanism by which international law actually is incorporated and transformed, that it actually reigns supreme and is part of the law of the land. Of course, our Constitution allows for, depending on the current trends, depends for, as some theories like Father Bernas would say, it can yield to either theory, but that would depend on the jurists of the High Court.
So when the Philippines enters into a treaty with a foreign country, once the treaty is ratified, it becomes a part of the law of the land under which doctrine? The doctrine of incorporation or the doctrine of transformation?
In the ratification scenario, it actually is incorporated under both theories.
It's under the doctrine of incorporation. So in the doctrine of transformation, you need legislation to implement the treaty so that it will become a part of the law of the land. All right. The other matter asked by Judge de Monteverde was on the good conduct time allowance. Ambassador TEEHANKEE, do you agree with the decision of the Supreme Court that the application of the law on the amended good conduct time allowance should be made retroactive? Because a group of inmates filed a petition before the Supreme Court when the Department of Justice came out with the IRR implementing rules and regulations indicating that the application was prospective. But the Supreme Court decided last few months ago that it should be made retroactive. Do you agree with that decision, and why?
Under constitutional, the Bill of Rights, laws are interpreted in the best interest, liberally, in favor of expansive rights of the accused under the criminal justice system. So there have been cases and doctrine in the past that say that amelioration of penalties, improvements or lessening of sentences are to be interpreted in favor of the rights of the accused or the individual, and that is why they are allowed to have retroactive application. While more stringent or increased penalties or increased punitive measures, laws providing for such are required to be applied, applied prospectively. And this is in line with the constitutional prohibition on ex post facto laws.
Justice LLOREN, the same question. Do you agree with the Supreme Court decision saying that the law amending the good conduct time allowance be made retroactive?
It is my answer, Your Honor, that it should be retroactively implemented, because any principles of law or provisions of law that would favor the accused should be accorded to the accused. Since this law is favorable to the accused, then it should be applied to the accused, Your Honor. It should be applied retroactively. In our
Do you
juris-
agree with that this is a penal law?
No,
What
this-
is your understanding of a penal law?
This is not a penal law, Your Honor. It is even one way of extinguishing the penalties by reducing the penalties. But in so doing, Your Honor, this is favorable to the accused. So therefore, it should be applied to the accused. Because in our justice system, Your Honor, we are in the second. I forgot the term. I'm sorry, I
Go
forgot.
ahead, go ahead, go ahead.
That any law should be resolved in favor of the accused, Your Honor.
Justice Sorongon.
Yes, Your Honor.
The other day, the President announced to the media that he was giving the prisoners, the convicted prisoners who were released pursuant to the Supreme Court decision, making it retroactive, and who qualified under the good conduct time allowance, a number of days to surrender, otherwise they will be arrested. Is that order of the President valid? Can they be arrested solely on the basis of an order of the President?
Your Honor, I would agree that the President has the power to do that under the concept that is the Commander-in-Chief and applying the police power. He can do that, Your Honor. Not necessarily a warrant of arrest should be issued against these people.
You do not need court intervention to cause the arrest of these convicts who were freed on the basis of a law and a decision of the Supreme Court.
Well, if I will premise my answer on my previous answer to Judge De Monteverde, then it needs a court order from the court where these accused were convicted. The tenor of the order would be for them to appear and surrender themselves.
Do you agree with that, Ambassador TEEHANKEE, that they can be arrested if they refuse to surrender solely on the basis of an order from the office of the President? And if so, why?
Your Honor, while not my specialty, if I suppose under the rules of the interview process, I must attempt to answer the question to the best of my ability. Under the presumption of regularity of official acts, I will first of all presume issued orders from the office of the President. I would give it the presumption of legality. Following Justice Sorongon's interpretation, there are, of course, situations where through the police powers, you are in fact asked to appear lest you have the risk of further executive or prosecutorial action. In the current situation, we have a very tricky situation where allegedly there are convicts or prisoners who might have been released through certain procedures that are now in question. And it is incumbent upon the executive to then pursue for the safety of the citizenry that there is a proper monitoring of the so-called number of released convicts, or assuming and presuming that they have been validly released, because we cannot also assume that all of them followed certain irregular procedures, that they must then submit themselves, and if they have nothing to hide, that all their procedures are fine. They are merely submitting to the proper monitoring by the police authorities of their status, and that if they are dutiful citizens and properly allowed the good conduct allowance and have done their time, there would be nothing on their part to hide from or to be worried about. So I think in the interest of the public order, compliance must be made with this order in order to afford for the safety of all and to go through all the proper vetting of the procedures. This is without prejudice, one way or to the other, to the final resolution of the procedures for each and every individual, and for each and every individual's rights to be protected and vetted.
My last question, which I will address to the three of you, is on the matter of academic freedom. Justice LLOREN, what is your understanding of academic freedom?
Academic freedom, Your Honor, according to my understanding, is that the teacher is allowed to discuss anything under the sun on his classroom, provided that it's not obnoxious. For example, he cannot discuss about sex, or he cannot discuss about pornography. But he can discuss what philosophy is all about, what's the theory is all about. Anything that comes to my mind, come to his mind that is proper, he can do it, you know, under the freedom of academic freedom, Your Honor.
If the professors and the faculty members of a school encourage students to go out into the streets to join rallies and demonstrations, will it enhance academic freedom or impair academic freedom?
It depends upon the situation, Your Honor. For example, in Hong Kong, I think it is within the academic freedom of the professors.
Are the demonstrators in Hong Kong students? They're not students, so there's no comparison. What I'm saying is, in the Philippines, if faculty members of PUP, for example, encourage the students to join demonstrations and rallies in the streets to air grievances against the government, will it enhance academic freedom or impair academic freedom?
I think it's no longer within the coverage of the academic freedom, Your Honor. Because
which is which? Will it enhance or diminish? Diminish. Why? Why will it diminish academic
Because
freedom?
it promotes anarchy and disorder. Not holding a class and telling them to go out to the street is no longer proper for me.
Justice Sorongon, what is your understanding, sir, of academic freedom?
Yes, there are 4 elements of academic freedom. One is who shall teach, what shall be taught and how should it be taught, and who shall be accepted. That's my understanding of academic freedom.
All right. If faculty members or teachers encourage students to go out to join rallies and demonstrations and not to attend classes, to air grievances against the government, and the school heads, the owners, the school administrators threaten to fire these faculty members who will encourage students to join rallies and demonstrations, will it enhance or impair academic freedom?
Of course, it will impair academic freedom. That's already beyond the rights of the school to encourage these actions by the students. Students are there to be taught the right morals, the right characters, but not to encourage them to go to streets and demonstrate. So that's already exceptions to the academic freedom, Your Honor.
Ambassador TEEHANKEE, there was this case of a teacher in a private institution. She was engaged to be married, but the boyfriend backed out and married somebody else. Unfortunately, the teacher was pregnant. And under the school manual of the school, there is a clause on morality. And so the school encouraged the teacher to resign. And the teacher refused to resign. And the school filed a case, a labor case, against the school for, although she resigned, she filed the case against the school for constructive dismissal. The school invoked academic freedom in the promulgation of the school manual. First of all, can you explain to us your understanding of academic freedom and whether that defense can be invoked by the school owners?
Academic freedom, of course, relates to the full panoply of rights and ability to exchange ideas and to engage in the act of imparting knowledge to students. So academic freedom includes the rights of teachers as well as the right of academic institutions. But one way to circumscribe and contrast and know the boundaries of academic freedom is its contrast to the freedom of expression and freedom of ideas. Academic freedom is limited to the context of imparting knowledge and having all the rights related to running an academic institution and imparting this knowledge. So it does not relate to the full panoply of rights of freedom of expression, which somehow relates to your earlier interview questions as to inciting or encouraging students to go to the streets, which are freedom of expression rights and are not necessarily protected under and not necessarily within the ambit of pure academic freedom.
But in the question cited,
in the question cited,
the school manual is being questioned
yes,
by the teacher. And the defense of the school administrator is that it is in the exercise of academic freedom and therefore third parties are not supposed to intrude or interfere in that.
Yes, in going directly to the question, it is an allegation of defense against the constructive dismissal case that it is part of their academic freedom to choose and impose the criteria and qualifications of their instruments of knowledge, their professors and teachers. While that is indeed part of academic freedom, the rights, however, are this qualification of morality in the current situation is not subject of a valid defense of academic freedom, since she had filed a case of constructive dismissal, which is violative of rights against discrimination, rights against due process. So my position is that the institution cannot assert academic freedom to defend itself from the dismissal.
So was the dismissal valid in that particular instance?
The constructive dismissal, in my view, of course, I would, in a collegial setting, be very open to discussion and persuasion. But my initial view, without yet the benefit of full research, is it would not be a valid defense.
Chairman, that is my last question. Thank you and good luck.
Thank you, Justice Tia. Judicial.
All right, thank you, Justice Mendoza, Chairperson of this Council. Good afternoon, Your Honors. How are
Good
you
afternoon,
today?
sir. We're fine, sir. Thank
Fine.
you.
How fine? What did you find?
Just enough.
Good.
We're
Oh,
good.
good. Okay. Yes, Ambassador Manuel TEEHANKEE, how come you remained unmarried?
I
How
have-
is single blessedness?
Well, no one has had given me the yes answer. So
At your age of 61 years old?
61. And I have actually devoted myself to my work and dedication to public service. And I am quite content, but am actually open should there be someone in the future.
Still open.
Yes.
How open is it? Or how often is such open? Is it an advantage? So
Well-
it's by choice
Yes, it's by choice because
and at the
I
same time
do.
by chance.
Yes, both by choice and by chance. And I have, of course, I am grateful and thankful for my career, which I have devoted myself to, and at least also have had the opportunity to serve in the Department of Justice and the Department of Foreign Affairs, as well as in my academic career, which is as a professor of international law. And so I look at, of course, I have quite a number of members in my family that I'm very proud that I am part of a large family. We are 9 siblings, and there are already 30 next generation and 18 fourth generation in our family. So I do have the benefit of family support, and which I'm very proud of.
How is your brother, Claudio TEEHANKEE Jr., who was released in 2008? How did you feel when he was involved in the case?
Of course, it was quite regretful, and our family is quite regretful for the pain that it has caused. And of course, we are also grateful that he has served his time and his sentence, and that he has paid his dues to society and is now living a quiet life. But of course, there is no substitute to penance and regret, and for all of us to learn that one must indeed abide as much as possible by the law and live a moral and upright life.
Arat, your credentials are quite impressive, seemingly. You have 2 masterals. One is from the University of Michigan, DeWitt Scholar. The other one is London School of Economics and Political Science. Am I correct? And also a PhD, Graduate Institute, Geneva. So with such varied work experience, which post do you think best prepared you for justiceship?
Of course, to a lawyer, to be able to serve on the High Court is one of the highest possible privileges. And I do not, I think it is a position to be aspired for, but it requires continuous learning. In terms of my studies, I look back on all of these studies as contributing to my ability to contribute in the field of international law and international economic law, since my studies have focused on international trade law, international investment arbitration, and public international law. At the same time, looking back on my training and career, my years at the Department of Justice and at the Office of the Government Corporate Counsel also did yield for me valuable experiences, and also my appearance before the Honorable Supreme Court as well. And my diplomatic years at the World Trade Organization involves also overseeing international cases that have involved the Philippines before the World Trade Organization. So, to briefly answer the question, I look upon continuous study and continuous learning, which I expect to gain from a collegial body such as the Supreme Court.
And there is no quarrel that you don't have any judicial experience as compared to other applicants who are now justices of the Court of Appeals. And why should this council choose you without judicial experience?
Similar to my father, who had served as Secretary of Justice before being appointed to the High Court, I think there is a benefit to the Supreme Court of also recruiting from the executive branch or other branches, other aspects of the law. My experience, while not in the judicial branch, is also in the field of the law and justice, having served in the Department of Justice and having handled also international cases for the Republic. So, if that can be my contribution, I would welcome that. But of course, I do respect that it is the highest honor for a lawyer, and of course, judges of the Court of Appeals and other members with experience in the judiciary are, of course, well suited to be a member of the Supreme Court.
All right, thank you. Per record, you have a labor case for wages due filed by a certain Gina Angulo in the Swiss tribunal, and you were found guilty and was made to pay the amount prayed for plus penalty of 400 Swiss francs. Could you narrate to us the circumstances that led to the filing of the case against you in the Swiss court?
In this respect, it related to my first posting as ambassador in Geneva. During the time that I had just arrived in Geneva, I had availed of the services of Ms. Angulo. And while compliant with the wage as sanctioned by the Department of Labor at the time, which was $200 per month at the time, under Swiss law, the minimum wage was higher. So upon learning of the discrepancy, with counsel, I did take steps to restore the full minimum wage required under Swiss law. And I have as well a court-approved settlement wherein the full amount plus additional amounts requested by the complainant were fully sanctioned and approved in an amicable settlement.
And looking back, could you have done things differently? And what's the equivalent of the amount so adjudged against you, Ambassador? In peso?
In pesos, the amicable settlement was 7,000 Swiss francs, equivalent to around $7,000, which is around 350,000. So well beyond the minimum required. And this was approved by the court as a mutually agreed and court-approved settlement. And to round off to the question, I do acknowledge with very deep regret that unfortunate misunderstanding regarding the level of required wages, which, as I said, while compliant with Philippine rules, were required to be higher under Swiss rules. No harm was intended by me, and all wages, as sanctioned by Philippine and Swiss regulations, have long been paid and settled. I also do wish to state for the record that I have learned well from the experience and fully support and advocate that all of us in government be committed to the welfare of our compatriot Filipinos. And I do regret very much this incident as a mark, and for which I have gained experience and learned from it.
There is a JBC rule that applicant who had been adjudged guilty and have been found with a penalty of more than 10,000 pesos is or are disqualified. What is your take on this provision of the Judicial and Bar Council?
In that respect, I do note that this is, as provided in the court document, this is a mutually agreed settlement. It is not a fine or an adjudgment. And as provided in the, since it is a matter of civil settlement between the two parties having duly approved court sanction, then therefore this is merely an adjudication that is part of a mutually agreed settlement, Your Honor.
So, your work experience locally and internationally have been found in your records. From your perspective, what are the issues plaguing the ordinary Filipino vis-a-vis our justice system?
I suppose this is in the national legal system as opposed to international law, Your Honor, Justice Ilaw. In terms of my exposure to the justice system and the concerns of our fellow Filipinos, one of the largest concerns is the clogged court systems. And so, while at the Department of Justice, this was one of my advocacies for the speedy disposition of cases. Even both in the judicial system of civil litigation as well as in the judicial system involving criminal cases. As we all know, the judicial system is one of the pillars of functioning government, and the smooth functioning of the judicial department is one of the greatest services we can have for our fellow Filipinos. Because as we improve the civil litigation system, so do we improve the economic system and processes of our republic. And as we improve also the criminal justice system, so we improve rehabilitation, we improve also the proper conviction sooner than later of criminal offenses, and the sooner rehabilitation also of those who have paid for their crimes.
So, if appointed, what is your short-term plan and a longer-term plan for the Supreme Court if you are appointed?
If it should happen that I would be accorded such a privilege in the High Court, my short-term plan, of course, is to learn as much as possible about all the rulings of the Supreme Court, having served in the diplomatic sector for the last 10 years, more than 10 years, and having left the Department of Justice in 2004. So that would be the first short-term challenge, is to really learn as much as I can. As you mentioned, nominees, candidates from the bench are, of course, highly experienced in the art of decision-making. So this would be one of my short-term
To learn?
to learn as much as possible about
Do you think this is,
judicial system and the judicial rulings of the Supreme Court and the art and craft of decision-making.
On-the-job training, Ambassador?
Yes, Your Honor. The second aspect I would contribute and plan for the long term is to contribute in the areas of my study and the areas where I can contribute to the court, which is my knowledge in international law, international economic law, commercial and tax law, as well as investment arbitration and investment law and treaties. So this, Your Honor, Justice Ilaw, would be my plan.
Thank you very much, and good luck. Oh,
Thank you.
yes, Justice Edgardo T. LLOREN.
Yes, Your Honor.
Could you tell us why you moved to a different law school?
Oh, yes, because I was a working student, Your Honor. I was assigned in, I started in Cagayan de Oro. I was assigned in, I started in Cebu, excuse me. I started in Cebu, then assigned in Cagayan de Oro, then I continue my study in Cagayan de Oro, Your Honor, and decided to settle there in the land of promise.
You have been a magistrate in the province your entire judicial career?
Yes.
MTC, Magsaysay, Misamis, Oriental.
And
Yes, we have this Manolo.
Manuel
Portis,
Portis also, Your Honor.
Mostly in the provinces.
The Manolo Portis is Bukidnon, and Magsaysay is Misamis Oriental Province. But they are connected, Your Honor, adjacent to each other. I transferred to Manolo because I am based in Cagayan de Oro. Manolo is nearer to Cagayan de Oro, Your Honor. I made a lateral transfer.
So, what nuances do you expect in the National Capital Region, if and when you're appointed, that you are not used to in your previous assignments?
I can easily adapt, Your Honor. That's not a problem to me.
All right, Canon 2 of the Code of Judicial Conduct states that, and I quote, a judge should avoid impropriety and the appearance of impropriety in all activities. How have you embodied this requirement?
Your Honor, please, will you examine the record for the last more than 35 years in the judiciary? I have never been suspended, fined, reprimanded for immorality, corruption, sexual harassment, or any untoward behavior, Your Honor. And of the 9 administrative cases against me, they were all dismissed, and 2 of them were the one fined by the Supreme Court for using the administrative proceeding as instrument of harassment. I have with me a copy of that decision as my trophy, Your Honor.
We have here your record of cases, 9 administrative cases.
Yes, they are all dismissed.
Although they've been dismissed. Are these cases not indicative of your work ethics, Justice?
No, Your Honor. I decide my case in accordance to in accordance to the light of what God has given me. I shall then not be moved by pride, prejudice, or pettiness in rendering decision, and I shall not be treated of an administrative case that will be filed against me.
Have you penned a decision that was contrary to your personal moral belief?
None whatsoever, Your Honor.
And how do you keep yourself abreast with recent legal developments or jurisprudence?
Your Honor, my office will be disturbed if we will receive decision coming from the Supreme Court that is of transcendental importance, not in the usual decision released by the Supreme Court, because most of the time the Supreme Court will release its decision is about alibi, chain of custody, and so on and so forth. But when we talk about co-warranto or something like that, then everybody must be disturbed. Or this CG controlling now in the newspaper. Because it calls the attention to us, Your Honor, because the way we look at it, there's a class of provisions between Article 27 and Article 97 and Article 29 of that provision, Your Honor. That's the problem why this is now a very big issued by the government. To my mind, Your Honor, this law was not properly studied.
You mentioned about the co-warranty proceedings, co-warranty case?
Yeah.
Proceeding.
Yes, that's a case of transcendental importance. That's not happening all the time. So when there are cases that will come up with the Supreme Court, then will be disturbed. Not all cases decided by the Supreme Court that will give so much attention because they are repetitious.
What is your takeaway from the ruling of the court in Republic versus Sereno? You mentioned about co-warrant.
That's almost split decision, Your Honor.
Almost what?
That's almost split decision. There's only one vote that distinguishes between left and right.
So what was the declaration record in demarcation?
My personal opinion,
Demarcation, please.
demarcation, it's almost tie, Your Honor. There's only one vote.
And what did the court say about public office, reminding government employees or government officials?
Public office is a public trust. Everybody is accountable from janitor to the president, Your Honor.
Have you read the case of Inocentes versus R. Sihuco Construction, GR number 237020, July 29, 2019?
No, Your Honor, I'm sorry.
Yes. Right, Justice Lawrence, the last question, that's a fair record. We have the list of your inhibited cases. From 2008 up to the present.
Yes.
You did not indicate the reasons why you inhibited or...
They are indicated, Your Honor. I have a copy of the report.
With a total of 334 cases?
Yes, from the time I assumed office until today, I inhibited, correct, Your Honor, I inhibited 300 cases more because, number one reason, my son was practicing lawyer, and I should inhibit in the law firm where he is connected. My wife also is as a profession connected with a banking company. I have also to inhibit. And also my neighbors, Your Honor, my former clients, my friends, because I always remember that judicial decorum, a judge must always maintain beyond suspicion, like a sister's wife. I do not want to give undue problem to my court, Your Honor.
That's one of the reasons why you have a low caseload?
Yes, Your Honor.
Inhibiting yourselves?
No,
Oftentimes?
because those inhibition, Your Honor, will be replaced of the same kind of case and the same statute. The moment you will inhibit, Your Honor, there will be a corresponding case to be rappelled to you. The reason why I have a very low caseload, Your Honor, because number one, I will not use my vacation leaves. I have more than 1,000 vacation leave credits because I prepare to work than take a vacation. I am the first to arrive in the office and the last to go home if I have so many problems in the office and so many works to do. I am an alcoholic, workaholic, Your Honor. Not alcoholic. I am a workaholic, Your Honor. No. My wife will not be happy to hear that. In the evening, Your Honor, after office hour, I went to law school teaching. I have been teaching there for the last 22 years. And I always got a rating of excellent professors. You want to have a copy? I have a copy with the evaluation, Your Honor.
Thank you, Justice LLOREN.
Thank you, Your Honor.
All right, Justice Sorongon. How
Yes,
are
Your
you
Honor.
again today?
I'm fine, thank you, Your Honor.
You tap on my list of how many administrative cases do you have? 1, 2, 3, 4, 5, 6, 7, 8, 9. The same as Justice
Yes.
LLOREN.
That includes the cases filed when I was still an RTC judge, Your Honor.
Say that you have embodied the principle of integrity, Justice.
Yes, Your Honor.
Why do you say so?
Well, my records will speak for itself. Simply because that there were cases filed against me, it doesn't mean that I do not embody the the virtue of integrity, Your Honor. I always exercise high ethical and moral standards in my dealings with my peers and in my job, Your Honor.
It appears that there are some cases filed against you which, while dismissed, were not disclosed in your PDS. Could you explain this discrepancy?
What? I have placed all those cases, Your Honor. They were all dismissed.
Are you disputing the comment of this?
No, Your Honor. Maybe sheer discrepancy, or I would have missed it, Your Honor. But certainly it was an honest mistake, probably, Your Honor.
But applicants are required to disclose all cases,
Yes, I know. Yes,
even any case.
yes, Your Honor.
How does Mayor Nieto know your professional competence, integrity, independence, and probity?
Well, Your Honor, Mayor Nieto lives in the same subdivision where I also live. We have been neighbors since 1996, Your Honor, up to the present. And he was still a practitioner, and I was already a judge then. We already know each other.
Are you aware of judicial ethics
Yes, Your
or
Honor.
legal ethics in the Philippine judiciary?
Yes, Your Honor.
That the magistrates should avoid impropriety and even should be free from any interference or intervention in a case handled by you.
Mayor Nieto never asked any favor from me, nor he had exerted any effort to influence me, Your Honor. And in fact, when I was still a judge, he never appeared before my sala, or when I was still a prosecutor, he never appeared in my cubicle also as a party, as a lawyer, or what else, Your Honor. We maintained, I included him as my reference because he's a family and a close friend, not because he is a mayor, Your Honor. That's only incidental that he happens to be a mayor, but our friendship transcends before he was still an ordinary citizen of Cainta, Your Honor.
This is the first time that you are applying as an
Yes,
associate
Your
justice.
Honor. Yes, Your Honor.
All right, can you tell me something about yourself which is not found in your application requirements?
Well, I'm a very good basketball player, Your Honor. I could have been a professional basketball player if not for my father, Your Honor. When I was in high school, I was already a varsity. In college, I was a varsity. But my father told me that I have to be a lawyer. So I followed the advice of my father. And so I stopped playing formal basketball and instead proceeded with my law degree. But despite the fact that I was already a law student, I still play basketball, Your Honor.
So you know how to dribble?
Yes, Your Honor.
Dribble cases?
No, Your Honor.
Okay, sorry.
No, Your Honor.
Excuse me. And why did it take you so long to apply as an Associate Justice of the Supreme Court?
Your Honor, I thought of this time as the opportunity now for me to apply. I did not think of the previous years of applying because I still have to gain more experience, more knowledge, and more in-depth study of the law before I engage myself in this exercise now or in this activity, Your Honor. 9 years with the Court of Appeals, I think, is enough and sufficient for me to be ready and go for the next level in my judicial career. You know. I believe that at this age of mine and with my experience, I am now equipped with the necessary tools to apply for the next level, Your Honor.
So why leave the Court of Appeals? Are you comfortable in leaving your position?
Yes, Your Honor. Not that I'm not. What I'm saying, Your Honor, I'm now ready to go to the next level of my judicial career. That's why I only applied now, Your Honor.
So what preparations have you made to take on the challenges?
Well, in the Court of Appeals, I have been deciding all kinds of cases, Your Honor, and I have been working with my lawyers, especially on new cases and recent decisions of the Supreme Court to make me abreast with the recent rulings of the court. So although I don't have any special educational what you call these conferences and seminars attended, but the fact that I have been working for 9 years in the Court of Appeals doing adjudication work makes me ready for the job. The only difference with the Court of Appeals and the Supreme Court is that the cases have tremendous impact on the political, social, and economic life of the people here in the Supreme Court.
All right. If appointed as an Associate Justice of the Supreme Court, what do you believe will be your most contribution to the Supreme Court?
Well, at this moment, the only thing I can say, my contribution maybe is to help in the resolution and the decision of cases in the Supreme Court, Your Honor.
That was my last and final question. Thank you, Justice, and good luck.
Thank you, Your Honor.
Thank you very much. Judge Silao, I will address this question to Ambassador TEEHANKEE. Yeah. What was the nature of that case under Swiss law? Was it a criminal case or a labor case?
Labor, Your Honor.
It was a labor case. Okay. We have no time now, but can you put in writing the reason why you should not be disqualified under the rules of the JBC within 3 days?
Yes,
Or 5 days? I'll give you
yes,
5
yes,
days.
Your Honor.
Okay. Are you aware of the rules of the JBC on disqualification?
Yes,
and
Your
the
Honor.
requirements?
Yes, yes, Your Honor.
You mentioned earlier about ex post facto law regarding GCTA. Can you explain that? I do not know if I got it right. Was there an application or interplay of ex post facto law there on the theory of retroactivity?
It is, yes, Your Honor.
Yes.
The ex post facto law is prohibited in the sense that ex post facto laws are frowned upon and not allowed, in the sense that more severe penalties are thereby not possible to be applied retroactively.
Okay.
However, the doctrine of ex post facto law, which prohibits retroactivity, does not apply where the law is applying retroactively in a more favorable manner.
Your position is that how about the GCTA? Are you familiar with that? Sorry. Covered by Republic Act 10195?
Yes,
10592.
well, in that case, it is the law itself is silent on its retroactivity or prospectivity, from my understanding.
Yes.
And the regulations were the one that were expressly made to be prospective, and it was required to be, by decision, favorable to the accused. It can be applied retroactive.
The IRR of the Department of Justice. Good conduct time allowance has been in our laws, even when you were the Undersecretary of Justice. What is the role of the Secretary of Justice regarding the application or computation of the good conduct time allowance?
Since the Secretary of Justice administers the procedures for clemency and supervision over application of penalties, they are also in charge of the application of, through the Board of Pardons and Parole, the calculation of these calculations for good conduct credit to time served. So on that issue, I am actually deferring to further reflection as to whether the IRRs of the Department of Justice could supplement the application of the good conduct time allowances. But as explained earlier, that is the decision perspective taken by the court.
The issue there was only about its, there was a provision in the IRR that it can only be applied prospectively. So the court struck it down and said that it can be applied retroactively.
Yes, because the IRR implementation and passage of the IRR took the view that the law was to be applied prospectively. And so the court stepped in and said that the law was actually silent. And so the IRR taking a position was slightly beyond the provisions of the law.
Under Republic Act 10592, how many provisions of the revised penal code was amended?
I regret to be unable to answer that question, Your Honor.
You have not read the law, the original of the law?
No, Your Honor.
I will cite Article 99, who grants time allowances whenever lawfully justified. The Director of the Bureau of Corrections, the Chief of Bureau of Jail Management and Penology, and or the Warden of a provincial, district, municipal, or city jail shall grant allowances for good conduct. Such allowances, once granted, shall not be revoked. Grant personnel. Can this be revoked by the Secretary of Justice?
Under the law, they are not revocable. Not revocable.
So the President cannot order the arrest of those who were released.
In this respect, as mentioned earlier, there are questions on the procedures leading to the grant. So, what I'm understanding, and of course I defer to further factual study, which I am not, it not being before me, I am not aware, but the question is the grant. While not revocable as an action of the officer, the question of the grant is the question at hand. Whether the grant itself by the authorized persons were valid. And that is not a question of revocation. That is a question of implementation and verification of the process of the grant by the authorized persons.
Well, the President ordered the arrest of those persons. Can he do that? Was there a proceeding questioning the revocation? Is the Senate proceeding such proper proceeding? If not, what should be the proper proceeding?
Again, I defer, not being my specialty, to Your Honor's advice and the advice of the ones hearing the case. But as I said earlier, given the presumption of regularity of executive action, this can be taken in the spirit of an order to appear. When the NBI or police say, please appear on your own volition to register or make your appearance known, it is often taken very seriously. Because if you have nothing to hide, you will make your appearance and make sure your book is open and that there's no further questions that could be asked. I would interpret the current situation as mentioned, please register, please appear, so that no further action will be taken, because the question is whether the grant of the allowances were duly made, and if they are duly made, you're just appearing, showing all your records, and justifying the grant of good conduct allowances, which I would, of course, in the advocacy of human rights and advocacy of rights of individuals, we would want to review and make sure that those good conduct allowances, where proper, should also be acknowledged and recognized. As we said, we cannot assume that all one plus more than 1,000 were all defective, but it would be incumbent to verify and check that the grants were proper.
Suppose a released prisoner refuses or declines the invitation.
my understanding is the consequences would be a thorough review and closer scrutiny of the grants in order to verify whether they were in fact properly processed. And if there is a question on that, those grants can be questioned. So that would could lead to, not exactly a revocation if they are void ab initio.
What should be the proceeding? It says, such allowances, once granted, shall not be revoked. In what proceeding should this be revoked? Declare that this should be revoked.
There would have to be a proper proceeding that the grant was void ab initio.
What should be the proper proceeding? The
The-
law is silent.
The law is silent and, yes, Your Honor. So I would defer to the specialists and the opinion of the Secretary
You are a
of
former
Justice.
Undersecretary of Justice, right?
In my own humble
Yes.
submission, I would then, since I would then apply for an immediate review of the grant, and so there would be a review process with the granting review process of the grantor.
When you were in the Department of Justice, did you review such grants?
No, in my position, my specialty and area of expertise were the initially also processing of investigations and on the prosecutorial side, as well as more the international, the Chief State Counsel work relating to our international cases and international treaty obligations.
Justice Sorongon, you were asked
Yes,
a question earlier and you said the President can order the arrest because he is the Commander-in-Chief.
Yes.
Is the Commander-in-Chief above the law?
No, not really. No.
Did you say that they can be arrested because he is the Commander-in-Chief?
Using the police power of the executive branch, Your Honor, I answered that way in that argument. But the follow-up question queried to me by Justice Tiham, I said that since he was asking me about the process, so I think we can use the court where these inmates were convicted because their sentence have not been fully satisfied yet. So I think the court has still have the authority or the jurisdiction to call upon them to report. With the pronouncement of the President, I think the prosecutorial arm of the government can now use the court to make their position and to make their actions legal, using as the court to have these inmates bring back to court.
Okay, you mentioned process. Were the released prisoners given due process? Were they heard before they were ordered arrested?
Precisely, Your Honor, they have to be summoned or subpoenaed again by the court for them to show up.
Proceeding.
But that's the
You said the President can order the arrest. There was no
yes.
prior proceeding.
Yes. Now, with respect to my earlier answer about the President having the authority to, I would withdraw that answer, Your Honor.
Going to withdraw that answer.
Yes, I will withdraw that answer and
So-
maintain my second position
What was your
And
second
my second position is that it is through the court, via the court, that it will issue a subpoena or notice to the convicts or to the inmates to show up because their sentence have not yet been completed yet, Your Honor. Using as basis the pronouncement of the President, the prosecutorial arm of the government can now use that, asking the court to issue a notice or subpoena for these inmates to show up in appeal.
When you are granted good conduct time allowance,
Yes, Your Honor.
is not time deducted from your sentence?
Yes, Your Honor.
And if you are granted that, you are deemed to have served your sentence.
Yes,
Why do
Your
you
Honor.
say that they have not served their sentence?
Because, Your Honor, of this.
That is different from commutation.
Yes, Your Honor. The purpose of this court process, to have them called back again, is for them maybe to
Why-
explain.
Excuse me, why court process?
I am
Is,
yes, Your Honor.
Regarding execution of sentences,
Yes.
who is responsible? Does the court monitor them, or it is the
The Bucor, Your Honor.
Bucor or the Department of Justice?
The Bucor or
Why will
and
you
the
go
department.
again to the courts?
Well, Your Honor, I am basing my answer
The
on
court has no more jurisdiction, right?
yes,
It's
but in
final
so
and executory.
yes, but in so far as the
Service?
service or the satisfaction of judgment, it is now the problem. We have that problem now.
Yes, we
Because,
have that problem. Why do you go to court?
Well, Your Honor, because
Is there a grave abuse of discretion? What is the remedy when you go to the court?
no,
Action. What action? You are
you
talking
have to go-
about court proceedings.
well, the
What
procedure-
action?
Will you ask for certiorari?
Oh, pardon? Search warrant?
Certiorari, Your
Oh,
Honor.
certiorari.
Yes.
Grave abuse of discretion of whom?
of the Bucor, Your Honor.
Should you not exhaust administrative remedies and go to the Department of Justice? Why do you go to the courts immediately?
Well, I think time constraint, because maybe some of these inmates are now cannot be found anymore. So that's why.
So you want to file a
Yes.
petition for certiorari under Rule 65?
Under Rule 65.
And you
Your
call
Honor.
that
Grave abuse on the part of the Bucor.
Bucor? You
Yes,
go
Your
to
Honor.
the Supreme Court?
Yes.
Are you familiar
Are
with
you-
Gio
no.
Samar? Gio Samar case?
Yes, Your Honor, the
Yes.
case penned by Justice Jardeleza, yeah. Hierarchy of courts, Your Honor. Yes, Your Honor.
Or do you of origin?
That's why I'm saying earlier, Your Honor, instead of going to the Supreme Court, you go to the RTC, file the certiorari
Well,
against these Bucor officials, Your Honor.
does the court have jurisdiction over the execution of or the service of the sentence?
Well, I think
Who has
that's,
supervision over the?
well, I think that's the only remedy for me, Your Honor. That's my personal view. If we really wanted to have these inmates be properly accounted for, we have to use the court rather than, or maybe use the prosecutor arm of the government,
So that DOJ,
the DOJ.
not the court.
DOJ first,
Are you
then
not-
ask the court. Because DOJ
When do you
alone,
go to court?
DOJ alone, Your Honor, cannot, they don't have the power to call, subpoena, or call these inmates, Your Honor. They
What-
can invite, but I don't know if they can bring back these inmates back to court, Your Honor.
What do you call the power of the court or trial court after it has lost its jurisdiction?
we have the residual power or the residual power or
You are correct, residual power.
residual,
Okay, okay.
residual.
Is that covered by the residual powers of the court?
Well, following the Tan, Fidel Tan case, Your Honor, it says there that the court can still make a determination whether the bucor or the inmates had really satisfied or made or completed the service of his sentence, Your Honor.
Okay, I go back to Ambassador Tihank. Ambassador, you have been our ambassador for how many years?
1 year and 1 month. Before that, I was undersecretary supervising also international economic relations.
What is the Iron Curtain rule in our laws of succession?
Iron Curtain rule under the Civil Code laws of succession.
Yes.
I'm sorry, Justice Mendoza, maybe you can guide me more as this is not my area of specialty.
Oh. Justice LLOREN will guide you. What is the iron rule in?
Yes, Your Honor, in the decision writing,
Session.
and the decision writing, Your Honor,
Yes.
Article 992 of the Civil Code of the Philippines, wherein an illegitimate
Okay, you answer
Child.
correctly. The Chief Justice is watching you.
where an illegitimate child cannot inherit to the estate of the legitimate children, legitimate child, and the relatives of that legitimate child. Cannot, Your Honor. The illegitimate cannot.
Yes. It has been said, and it was even mentioned by Justice Gutierrez in Diaz, that there is no such thing as illegitimate children, but illegitimate parents, because they had nothing to do with their circumstances. Do you agree?
It's in the Civil Code and the Family Code, Your Honor. I cannot agree
Yes.
with him.
You cannot agree with him.
Yes, because illegitimate children are very clear in the Civil Code and in the Family Code.
Is not that a discrimination, a violation of the Equal Protection Clause?
I don't think so, Your Honor, because they do not have equal rights.
Yes, that's why I'm asking you. There is no violation. They are not granted equal rights.
No,
Are they to blame for being, quote-unquote, illegitimate?
no, Your Honor. They have no choice.
Your choice?
Yes,
if you
yeah.
are in the Supreme Court,
No, I mean,
if that issue will be brought to you, that Aquino versus Aquino presented to you is now pending in the Supreme Court.
Your Honor,
Should you be appointed as a Supreme Court Justice? What is your view on that?
no,
There is no violation of the Equal Protection Clause, or is there a violation?
I will lay first the basis, the premise, Your Honor.
Yes.
Now, when that child was conceived in his mother's womb, he was not given the opportunity to be called legitimate or illegitimate.
Yes.
Yes.
That's what.
So, but that's my chance that his mother and mother were not married.
So, lesser right, successional right. Is
Yes,
that
under-
not discrimination?
No, it's not.
It's not a violation of the Equal Protection Clause?
No, it's not, Your Honor.
What do you say, Justice Tian? Ambassador Tian.
Again, of course, if presented with this issue
Yes.
in a deliberative session of the High Court, I would, of course, undertake my own further research and as well as rely on the expertise of civil law experts. But at first blush, the equal protection of the law clause argues very much that each individual have equal inheritance rights. And of course, inheritance rights should flow from blood relation. And so it is very important that a careful factual study of the actual case is also undertaken, because there are several levels of blood relation in the modern evolving universe of family relations, as we all know. And so,
in Article 2, did you hear Justice LLOREN? An illegitimate child does not have a right to representation of this predeceased father or mother. That was the mother, no? Yeah. Oh, from his or her grandparents.
yes, so in this situation, of course, again, this would require careful factual review, and that is
Those
also
are the facts. Those are the facts.
yes. So in such situation, the ideal situation is that the legislative branch of government study these issues carefully, taking into account the Equal Protection Clause. As we have the law per se at present, there is the issue of blood, the level of blood relation, because without going into the meaning or insinuation or implication of the word legitimate or illegitimate, removing first the stigma or any reference to the term, the essential legal meaning of legitimate and illegitimate in inheritance law is the fact that the legitimate child is actually the product of a legally sanctioned marriage between two persons, resulting in a full-blooded heir.
Yes.
While the illegitimate situation, removing again the implication or insinuation of any social meaning to the term, the illegitimate child in pure legal terms is the product of a union that is natural and could be love, based on love, but there was no legal contract between the union of that man and woman that resulted in the product of the child. And so
the child has nothing to do with this status.
yes, however, since we are dealing with properties and proprietary matters owned by the parent and further parent, which are all the result of social unions and contracts under civil law, that is only the reason why I am cautious that it require a clear factual study, because there are concomitant results from these
Those are the
social
facts.
contracts.
No need to go further. Those are the facts.
Yes, and as
When we should you be appointed to the Supreme Court, will you be a judicial activist? Your understanding of judicial activism?
my understanding of judicial activism is the ability of the judicial branch of government to act in the spirit of the law and on the basis of policy, prescriptions, and advocacies. So my interpretation of judicial activism is a certain level of liberal interpretation of the law by jurists. And by nature, I am more conservative.
Are you conservative?
More conservative.
You believe in stare decisis?
I would explain this, Your Honor, perhaps in degrees. I would just say that where policy prescriptions are essential or fundamental and more closely related to basic rights, there is a level of judicial activism, but there is a certain degree by which one should not abuse this policy liberal spirit. Because the more it is stretched, the more there is a reaction for the pendulum to swing back to the other side. So I am not, if you then put me on the spot, I would like to be a centrist in that sense.
Justice LLOREN,
Yes, Your
you
Honor.
mentioned regarding the Hong Kong rally.
Yes, Your Honor.
What is freedom of expression?
Freedom
What
of
is your understanding?
Freedom of expression is under Article 3 and Paragraph 4 of the Constitution, which says that no law shall be passed abridging the freedom of expression and expression and the right to peaceably assemble to air their grievances, Your Honor. That is a protected speech. Cannot be subject to prior restraint.
What is its coverage?
What do you mean by its coverage?
Yes, or elements as one justice wrote in his ponencia.
Elements of what, Your Honor?
Freedom of expression.
Freedom of expression should not be threatened by prior restraint and subsequent punishment, Your Honor.
What do you mean? You mentioned subsequent punishment. Can you
Yeah, for example,
mention the whole phrase? The two
Yeah.
elements.
yeah,
You forget.
it's my-
Justice Sorongon will help you. Justice Sorongon.
No prior, there is no
Prior
prior
restraint,
restraint, then no penalty imposed, no. And that the speech should not the speech or the speech should not should always be in accordance with law, that it should not be contrary to others' belief. I forgot the
What
third
are
one.
the two
Oh, I forgot the
recognized
third.
forms of restraint?
Recognized forms of restraint. We have the
But TEEHANKEE.
I also am unable to remember
Cannot remember.
is it the
It is
present day?
no.
equal and
One
present
is the
danger?
content-based, restriction-based on the subject matter of the utterance, and two, content-neutral regulation. Restriction refers to time, place, and manner. That was
The two restraints.
cited in the Diocese of Bacolod case. Do you know that case? Oh,
this should not be voted for because they are against life. So
you remember?
I could hardly recall.
Team Patay and Team Buhay, you remember that?
Yes, yes.
Then,
Yes, Your Honor.
about flag burning, is that a form of expression?
Although it's a form of expression, Your Honor, but it is a criminal offense because there is a law that provide for its punishment.
It's not, what is that law?
Flag law, Your Honor, I think. It's a flag law.
It's Republic Act 8491. Is it not violative of the,
Freedom of speech.
yes?
Under Article 3, Paragraph 4.
Yes.
I don't think so, Your Honor. You can express other, you can perform other expression, but need not be an insult to the symbol of the Republic of the Philippines.
That is you.
Yes, Your Honor.
Ambassador TEEHANKEE, in the U.S., Laconia, New Hampshire, there was an ordinance passed prohibiting women from going topless in public beaches. 3 women defied the ordinance and were charged accordingly. Their motion to dismiss was denied. They went to it reached the New Hampshire Supreme Court. In the context of Philippine law, is there a violation of the freedom of expression?
There are, in the context of reasonable restrictions on freedom of expression, it would be by community standards a reasonable restriction.
Because in your position is that in the view of that community, going topless is obscene.
Without going further into
It is the obscenity law of
Yes.
Laconia.
It was probably their view, or it could be distracting.
You find mammary,
Cause car accidents.
you find mammary glands destructive or attractive?
I think they are two sides of the same coin.
So, in the context of Philippine law, so, will you uphold that ordinance or will you strike it down?
Yes, based on community standards and the reasonableness of the restrictions, it would be incumbent upon us to respect the standards of the community expressed through the ordinance.
It will be, I will turn over to the mic to Judge De Monteverde because he has not yet asked the 2 other justices. But he can also ask Ambassador.
Thank you. Justice Mendoza. Justice LLOREN, how is your health?
I play golf 3 times a week, 5:30 to 7 o'clock. I went to gym 5:30 to 7 o'clock, 3 times a week.
But how is your health?
I'm fine, Your Honor.
Well, last your medical record shows otherwise.
No, Your Honor, there's only a borderline of sugar. But I can melt it after the play golf.
It says here that is quite high.
What's that?
High. Your blood chemistry
The
and your
sugar?
FPS.
The blood chemistry, Your Honor, is only the problem there is the sugar.
Sugar and
what's
the borderline?
I think it's more than 6.
6. Okay.
I don't have the record now. It is a manageable.
You have resided in Cagayan de Oro for so long a time.
Yes, Your Honor. Since 1975, Your Honor.
And it is in Cagayan de Oro that you were first appointed as
Municipal judge.
Justice of the Court of Appeals.
Yes, Your Honor.
And you have stayed there as
Yes.
the Justice of the Court of Appeals since then.
Since 2008, Your Honor.
And that is probably the reason that you inhibited from hearing many cases.
Yes, Your Honor, because Cagayan de Oro is a small place.
334 all in all. 334 cases
Yes, yes,
all in
that's
all?
correct, Your Honor. But it did not unload my obligation, Your Honor, because I'm also correspondingly given the same equal amount of cases that I inhibited.
Was your
It
zero
did not lighten my
backlog,
load.
was your zero backlog the reason for your inhibition?
No, Your Honor, certainly not.
Okay.
And I committed a serious error, Your Honor, in my application that I was bragging that I got a zero backlog since 2004, and I have now the new certification from the clerk of court that since 2011, Your Honor, I have no more case submitted for decision. Last month, I only disposed 4 cases, the other month 5, the other month 3, because I have nothing more to do in my office.
Okay, thank you.
Thank you, Your Honor.
Undersecretary or Ambassador
As
TEEHANKEE?
you please, Justice.
Okay. You're honorable, sir. And how is your health?
I have general good health, although at 61, I now take a little dose of maintenance.
Because of what?
Maintenance for blood pressure.
Okay. You're just like Justice LLOREN, your blood chemistry is also high, your FBS. You're as shown in this medical record.
Yes, my blood sugar.
The blood chemistry was taken only last July.
I think it's within the range of normal, but on the high end for my sugar.
Okay. The late, your father, the late Claudio TEEHANKEE, Chief Justice, was known as the court's activist justice because of his dissenting opinions, which eventually became the majority, ruled in many vital cases. Can you cite a case which was penned by your father, and if given a chance to write a dissenting opinion about it, what would it be?
You mean I would choose, yeah, and then choose to dissent from it?
Yes.
It would be quite difficult for me to attempt to disagree with my late father, but I do recall his decision in that public office is a public trust, and the famous case of Gallman, but I would not issue any dissent. But so it's difficult to establish a dissent, especially since a lot of these cases relate to the upholding of civil rights and human rights.
And now, given your diverse history of government service, what do you think would be your greatest contribution to the judiciary?
This is an area where I am most passionate about. Since my law studies, I have been a passionate researcher and studier of international law and international economic law, with economics as my pre-law and my postgraduate studies focusing on international commercial law, as well as international environmental law and international trade law. My contribution would be to build on the knowledge of international commercial law and treaty law, which is all for the furtherance of economic progress. Especially in this age of globalization, international treaties now focus on economic cooperation among states and economies. And so I think it is vital for the development of the nation that we progress in our economic cooperation with other states, but all with the end in mind of furthering our own national interests and creating prosperity for our fellow Filipinos.
Now, in making decisions, do you always seek advice from other people, or do you do it yourself?
I first and foremost wish to study the facts.
Mm-hmm.
But how the facts will be interpreted, especially in a collegial body, it is really beneficial that we listen to the counsels for both sides and give their best arguments, because through that, the ideas are tested. And then, of course, apart from listening to the two sides, listening to the experts in the field, professors who are also expert in the field, whether they are amicus or through their texts, as well as the fellow jurists.
Justice LLOREN,
Yes,
you are now 68 years old.
68 and 1 day, Your Honor. 1 month, Your Honor.
60. Your birthday yesterday?
Last month, Your Honor. 68
And 1 month.
and 1 month old.
Okay. If appointed, you will be serving for only about 24 months, more or less.
Yes, Your Honor.
And in that short span of time, what do you think will be your best contribution to the judiciary and as Associate Justice of the Supreme Court?
First, I would initiate to take another look on our judicial system, Your Honor. Because the correct, to my mind, the correct description of judicial system should be triangle, Your Honor, where so many cases coming from below, then few cases only in going to the Supreme Court, like just in the Supreme Court, U.S. Supreme Court. They have no more, you have few cases, Your Honor, because they will only entertain issues of transcendental importance coupled with constitutional issue. In our system, Your Honor, it's a triangle reverse. For example, Your Honor, I can give you an example. I decided a case in Iligan City, coming from Iligan City. A postcard cost only a few peso. Brother and sister quarreling, kick the postcard, damage the postcard, went to the municipal court, went to the trial court, went to my court, went to the Supreme Court. There are so many cases, Your Honor. Now, if you have to change the rule, for example, Your Honor, if the penalty is not more than 6 years and 1 day, the final 6 years and 1 day appealable to the RTC, and the decision of the RTC final, so as to unclog the Supreme Court. For example, Your Honor, in the NLRC cases, Your Honor, ruled by the arbiter in favor of A, appeal to the commissioner, ruled by commissioner in favor of A, went to us, ruled in favor of A. No need to go to the Supreme Court. Final, so as to unclog the Supreme Court. Yes, that's one of my.
Would be your
that's one of my.
the best contribution that you can give
yes,
to the judiciary.
if given a chance. Another mission, Your Honor, is that these administrative cases are, let's see, demoralizing to the judges and have a chilling effect. We have plenty of judges here who are supposed to be promoted but cannot because of a pending case. They cannot receive their allowances, bonuses. Many of us do not know that a simple administrative case will take 8 years before it can be resolved. I'll give an example. Justice Borja, retired last year, he will be 1 year next week. Until now, he did not receive a single centavo because when he asked for clearance, he was told, "Oh, Your Honor, you have a case filed 8 years ago, administrative case." And then said, "Can I have the copy of the complaint?" "No, it's with the ponente." "May I know the ponente?" "It's confidential." "May I know the complainant?" "It's the complainant." "The complainant is from Davao." He called Davao. "Oh, I was able to contact the complainant. Can you please give me a copy of the complaint so that I can answer?" And the complainant said, I could not remember having filed the case against you." It's now 8 years filed. It's 1 month, 1 year now, he cannot claim. If I will be given the opportunity, Your Honor, if the supreme architect of the universe will give me the opportunity to sit there, I will devote, because I'm also a victim of that administrative case. I lost my opportunity to be awarded in the judicial excellence because there was an unresolved pending case. It took me 16 years to sit in the lowest court because there is a pending case. If I'll given the opportunity, Your Honor, I will see to it that from 6 o'clock in the morning to 8 o'clock in the morning, I will devote that time to resolve administrative cases because this is very unfair to the judges. Thank you, Your
Indeed,
Honor.
patience and perseverance will accomplish all things. Now, there have been many Supreme Court decisions, and can you remember one decision that you disagreed? Only one.
Only one? Yes,
Only one.
there was. Okay. It's about 9165, Your Honor. Okay, it's about drugs, 9165. I affirmed the decision of the Royal Court, and I was reversed by the Supreme Court. The facts of the case is that the pusher buyer was not presented in court. It's only the police officer who was seeing the transaction of the sale and buy and sale. But he was only 10 meters away. So according to, with your permission, according to the ponente, Chief Justice Serino, the testimony of that police officer is heresy. Because how can he see a small sachet with 10 meters distance? I was reversed. But how come, Your Honor, the busman, by busman he was with the accused? If there was no transaction,
Just
how
make
come?
it brief, Justice.
Huh?
Just make it brief.
Ah, yes. How come that the bypass money was in possession of the accused and he was acquitted? Although he cannot see the small sachet, but the money is there. Thank you, Your Honor.
Ambassador TEEHANKEE, the power to appoint judges and justices is lodged before the President. But there are some sectors who seek to remove from the President the authority to appoint judges and instead transfer the same to the Supreme Court. What is your opinion on this?
One of the great checks and balances on our system of government is the three branches of government, which is the legislative, executive, and judicial. The President, while head of the executive branch, is also the representative of all the people. And he represents the leadership of our country. So the appointing power is very much tied to his representation of the people, and is not merely part of the system of checks and balances on the three branches. When acting as president with the appointing power, he acts for the whole republic and the people. So I would preserve the system that we have known for a long time.
Your take, Justice LLOREN, on this?
May I know the question, Your Honor?
Well, the same question.
I was not listening to the question, Your Honor. Please, I'm sorry.
Okay, yeah. The power to appoint is lodged before the President.
Yes, Your Honor.
But there are some sectors who seek to remove this authority from the President and instead transfer it to the Supreme Court.
Appointment. You know, Your Honor.
To name the judges and the justices. Now, what is your opinion on this?
I'm sorry, I have to disagree, Your Honor.
Okay.
Because,
Why?
why? The reason is that appointment to the Supreme Court is more of political and at the same time destiny, Your Honor. If you want me to give an example, I can give you one.
Only one.
Yes, Your Honor. There was a brilliant justice of the Court of Appeals who was
But make it brief, huh?
Yes, Your Honor. I was nominated several times during Gloria time. Oh. He did not make it. He was nominated several times in Aquino time. He did not make it. But by stroke of luck, a man coming from the south became president. Who knows this guy? But he was appointed. I thought he was already a gunner. He is almost on his twilight years, but he's a gunner. Supposed to be. But by stroke of luck and by processes, Your Honor, You got it? Do you want me to know his name? No need, Your
I
Honor.
know.
No need.
I know his name. I
Yes,
have
Your
an
Honor.
idea.
Thank you, Your Honor.
Your opinion on this, Justice Sorongon?
I agree with the two gentlemen, Your Honor. That's the beauty of the separation of powers of the three branches of government. And I also agree with Justice Leonen that appointment to the Supreme Court is destiny.
That will be my last question, and may the best man win among you three. Good luck.
Thank you, Judge De Monteverde. Justice T.
Just a winding question. Your, Justice LLOREN, your recommendation to cut off the appellate process,
Yes, Your Honor.
to do away so that many cases can be resolved, is very commendable. You also agree that the creation of a small claims court where there are no lawyers have also expedited the resolution of many cases. So shouldn't we follow the advice of Shakespeare that we just kill all the lawyers? Okay, just one question. This is addressed to everybody. The President banned Rappler reporters from covering public events and even entering Malacanang complex. The palace did not give any reason for the coverage ban and also did not state for how long the ban would be in effect. So Rappler filed a petition for certiorari before the Supreme Court against the Office of the President, the Office of Executive Secretary, Judicial, the Presidential Communication Operations Office, seeking an end to the President's coverage ban against them. Now, Rappler argued that it violates the constitutional guarantees of a free press, free speech, equal protection, and due process. Later, 41 reporters, columnists from different media organizations filed a petition for intervention in that petition and argued that the vague reasons provided by the President and Malacanang for the ban has exposed other journalists to vulnerabilities of also being banned in the future. That case is still pending before the High Court. If one of you is appointed to the Supreme Court and it is raffled to you, how would you rule on this press freedom test case filed by Rappler? Is the coverage ban against Rappler constitutional or unconstitutional? Justice Sorongon, can you start?
I think the freedom of press has certain limitations. The President, yes, may invoke that privilege of banning Rappler from attending press conferences
Without giving any reason.
in
Except
Malacanang.
that probably
but-
the President is unhappy
Yes,
with
but
the way Rappler covers
Yes.
the event.
while there are certain limitations, but Malacanang should have properly explained and informed Rappler of such restrictions. What what have they done while they are being restricted from attending, and there should have been a limit or term for such limitation. But
So, would you consider the ban constitutional? A valid exercise of the powers of the President?
it is a valid exercise of the President, but it has some limitations. It should have been limited for a certain period of time only. And there should have been an explanation to Rappler why they are prohibited from attending the press conferences in Malacanang.
Justice LLOREN, what is your take on this? Do you concur with Justice Sorongon that the ban by the President against Rappler from covering Malacanang is constitutional, or would you like to dissent?
I think the question is that there were other journalists who filed a case.
That will be my next question.
I see. Okay.
So the pending question is whether the ban is constitutional or unconstitutional.
I think it's unconstitutional, Your Honor, because it is the prerogative of the people to know what's going on with the government. So this should be given the opportunity to cover or hear the sides of the government.
What
Not
about
to
the
restrict.
fact that although Rappler is banned from covering Malacanang, there is nothing that can prevent it from sharing information with the other media organization allowed inside Malacanang?
Now, there's what we call a broken glass policy, Your Honor. In the United States, they call that a broken glass policy. When there's a window, you throw a stone, it's broken. If you will not fix it, other stones will be broken. You have to throw another stone. It will disappear. Now, in this case, Your Honor, if you ban the Rappler, there's a tendency that you will ban also the others. Your kakabers, others will also follow. So I think there's a need to check on that, Your Honor.
Ambassador TEEHANKEE, the 41 other reporters, columnists, who filed a motion for intervention, saying that they are also affected, do they have legal standing to file the motion for intervention?
Intervention.
These 41 reporters, other media organizations, are not included in the ban, but they filed a motion for intervention because there is a possibility that in the future, their own reporters might be barred from entering Malacanang. Do they have legal standing?
In terms of legal standing, in order to be a petitioner, they would lack legal standing. But if they are filing as an intervenor, that is a discretion of the court to allow or not allow. It would be almost in the nature of providing amicus or elucidatory opinion, given their interest in the matter.
Is a generalized grievance or a sympathetic personality, they will similarly be affected in the future, vest legal standing?
No, Your Honor. No, Your Honor. The only similar or analogous situation would probably be like a taxpayer suit. So that's why my position would be, it would be in the discretion of the court to allow or not to allow the intervention.
And finally, will you concur with Justice Sorongon that the ban is constitutional, a valid exercise of presidential power, or will you concur with the dissent of Justice LLOREN that it is unconstitutional?
With the permission of Your Honor, I guess the caveat is the interview questions at the JBC is an exception to the sub judice rule.
Of course.
And okay, and in that
it does not, of course, amount to a prejudgment, because you are not, even if you become a member of the court, you are not fully apprised of the circumstances, the available information obtaining in the case, because this is still subject to deliberation. And I don't think people who heard you, including Rappler, will not file a motion for your inhibition.
Thank you, Your Honor, because that would be the second caveat, that this is more in the interest of elucidatory debate.
Academic discussion.
And given that risk anyway, of an academic discussion, I would just caveat that, of course, being not a specialist on this area of media law, I would initially study the facts carefully, listen to all my colleagues, especially the position of Justice Sorongon and Justice LLOREN on the two sides, and try to be persuaded one way or the other, because I would, in the initial stage, have a neutral position. Going further, in my initial research, I would also then assert that freedom of the press, like academic freedom, has a certain box. And this box relates to the ability to form opinion, gather facts, and disseminate in the media what they wish to express. As Justice Sorongon, I would assert that there is a certain level of executive privilege of access to the presidential press corps. Given that there is only a limited space in the room, it is a certain privilege to have access. This same issue is before the White House press corps. It also has the same issue in the Prime Minister Hour in the UK, that there is a limited number of spaces, and it is a privilege for the accredited press to be able to enter. I am sympathetic to Justice LLOREN's view that a straight-out ban of one organization could be deemed arbitrary or subject to abuse of discretion, because it is singling out a particular organization absent explanation. So I am 60% on the side of executive privilege, because there is a privilege not to be, as if we adopt the American approach of degree of irritability being a certain factor in the admission to the press room, it would be the privilege of the executive to choose who he's comfortable with, provided the freedom of the press, access to all information, the speech, the records of the press conference are all in any event accessible online or through live stream.
Just a final follow-up question. If at the end of the deliberation, you are a part of the court, you are conflicted, you do not know whether you are going to side with Justice Sorongon or with Justice LLOREN, what would be the convenient course of action? Should you inhibit from the case because you don't know how you will vote?
Inhibition would imply...
you just say no part for any reason? Or just go on leave so that you will not be present when the voting comes?
I think I would be duty-bound, absent any reason for inhibition, to contribute to the discussion, and if I am unable to fully concur or fully dissent, to issue a separate opinion.
Thank you very much. That's my last question.
Thank you, Justice Tiham. Judicial.
All right, thank you again, Justice Mindot. It's already 4:40, and we're not being paid for overtime. Anyway, just in closing. All right, Justice LLOREN.
Yes, Your Honor.
How young are you? 68?
68 and 1 month old, Your Honor.
Plus 1 day.
No,
Today. Tomorrow.
Tomorrow.
Okay. If today were to be your last day on earth,
Yes.
how would you spend it?
I'll spend it with my wife and children.
Okay.
Because they are the most important treasure in my life.
Okay. At Justice Sorongon, what do you want to
Yes,
be
Your Honor.
remembered for? Basketball player. Not dribbling cases, but dribble ball.
I would have to be remembered as a justice who is kind, generous to everyone.
Thank you. Yes, Ambassador TEEHANKEE. What is something that no one would ever guess about you?
I guess that something that no one would ever guess.
Guess.
Well, that I guess, an admirer of history. I love to study history and how the whole the world has evolved. And because my whole life I have been dealing with the law and diplomacy, although it is related, but many people would not know about my love of research into ancient civilizations.
All right, that was my last questions, and thank you, Your Honors, gentlemen, and good day. Good luck again.
Thank you, Your Honor.
Thank you.
Thank you very much.
Thank you, Your Honors.
Judge De Monteberti, no more? No more questions? I have no more questions also. You're all excused.
Thank you, Your Honor.
Permission to leave, Your Honor.
Permission to leave and approach.
Your Honors, that concludes today's public panel interviews. Thank you, Your Honors.